Hello, everyone. I'm attorney Kelly Bagla, and I will be talking to you today about doing business in the United States. So it is a land of opportunities. As the country with the world's largest economy, the United States offers some of the best business opportunities in the world. With a population of over 327 million, it offers a large consumer marketplace with domestic and overseas investments. The annual growth rate of the US GDP is about 3.14%, and with a GDP of about $22.32 trillion, and that's just in 2020. But the size and scale of the country can also represent significant challenges to the unwary. With 50 different states, the federal system seems that legal requirements vary across state borders. So maintaining compliance can be a real hurdle to a business entering the marketplace for the first time. Understanding the requirements of doing business in the US is crucial to a successful business expansion strategy. Here are some important information for you to consider when doing business in the United States. Entity choice. Let's start with that. A foreign company entering the US must decide on the form of business entity it will use to conduct its US operations. The most common types of domestic business entities are corporations and limited liability companies, also known as LLCs. Each business form has its own benefits, and the choice of form depends on case-specific legal and business factors. Each type of business entity must be formed according to the laws of the state in which the entity is formed. All entity types require organizational documents to be filed with the state government. A foreign company is not required to conduct business in the US through a US entity and could instead open a branch office. Doing so, however, is generally not advised for tax and liability reasons. A branch office, unlike a subsidiary, is not a separate legal entity of the parent company. A branch office is considered to be the foreign company operating in the US. If a foreign company establishes a branch office in the US and conducts business in the US, the entire company is considered to be doing business in the US. Let me repeat that one more time. The entire company, the foreign entity, is considered to be doing business in the US. This can subject the company to taxation on all income earned, rather than limiting taxation to the income of the branch office. Furthermore, liability of the foreign company can, or rather would not be limited to liability incurred at the branch level. Accordingly, foreign businesses coming to the US do not generally elect to open a branch office unless specifically advised to do so by a US attorney. Selecting one of the entity forms discussed below is typically more advantageous than opening a branch office. So let's start with corporations first. Many foreign companies do business in the US as corporations. Corporations are organized under state law, and each state has its own rules for creating and operating corporations. In the US, a corporation may be created under the laws of one state and have its principal place of business in a different state. So for example, you could be incorporated in Delaware, and you could have your principal business address in California. A logical choice is to incorporate in the state where the business intends to locate its operations. The state of Delaware, as I mentioned, is a popular choice for business to incorporate in due to predictable and business-friendly laws. To form a corporation, a certificate of incorporation must be filed with the Secretary of State, typically online, in the chosen state. In most states, the owners, also called shareholders or stockholders of a corporation, elect directors who set company policy and elect officers, such as a company president, vice president, secretary, and treasurer. The directors of a US corporation can be foreign nationals and must be natural persons, not foreign companies. The rules for operating the corporation are commonly included in the company's written bylaws. The initial structure and bylaws of corporations are similar across jurisdictions, but can be customized to meet individual company needs, which is obviously highly advisable. The most common corporation form is called a C corporation. A C corporations are taxed at the corporate income tax rate separate from the company's owners. This means that profits distributed as payments to the owners are taxed twice, first at the corporate level and second at the owner level. This double taxation can be avoided by US companies by electing to be treated as an S corporation, which is a pass-through entity for federal tax purposes. However, a foreign company cannot elect to be treated as an S corporation. US law treats corporations as legal persons, meaning that a corporation can enter into contracts, sue, and be sued, and carry its own liabilities as a natural person does. In general, individual owners can avoid personal liability for the actions of the corporation, and in the event of insolvency, the corporation can declare bankruptcy without putting the owner's personal assets at risk. It is, however, important for the owners to maintain corporate formalities and keep separation between the owner's personal affairs and the company business in order to prevent creditors from imposing liability on directors and owners personally. So corporations do have formal corporate compliance that they must follow in order for them to maintain that protective shield against personal assets of the owners and the business assets. So let's move on to limited liability companies. So another choice of entity is a limited liability company, also known as an LLC. Like a corporation, an LLC is formed by registering with the Secretary of State in the state in which the company is to be created. As with a corporation, an LLC is governed by the laws of the state in which the LLC is formed. So for example, if you form an LLC in California, California law will govern your LLC. An LLC must have at least one member, and members do not need to be natural persons. So for example, your LLC in California can actually be owned by another entity, another company, rather than an individual. LLCs offer flexibility with respect to how the company can be financed and managed. The owners of an LLC, called members, typically design and create an operating agreement which governs the operation and organization of the LLC. While most companies elect to create an operating agreement, doing so is actually optional. For example, under Delaware law, members are not required to adopt a written agreement, but without an operating agreement, the LLC will be governed by default provisions set forth in Delaware statutes. Likewise, if the operating agreement leaves out certain provisions, the default provisions of Delaware LLC laws will apply. So you have a give and take. If you do not want the default provisions of the LLC laws to apply to your company, it's incredibly important that you actually have a well-drafted operating agreement that's going to work for your company. Unlike corporations, LLCs can elect to be taxed as a corporation or to have income passed through to members and be taxed at a member level. Many foreign companies prefer to be taxed at the corporate level to avoid having distributions to members reflected on their personal tax returns. Like a corporation, an LLC has a legal entity separate from its members. Members' personal liability is therefore limited to their investments. As with corporations, creditors may only reach members' personal assets in limited circumstances where the members disregard the separate corporate identity of the company or use the LLC as a shell to avoid liability for a parent company. Along with incorporating, it's incredibly important, again, to make sure that you keep your business completely separate from your personal assets. You are required to have a bank account, a business bank account. And in order for you to obtain a business bank account, you are required to obtain an EIN, which refers to an employer identification number. And that actually acts as the social security number, if you will, the identification number for your company. And an EIN may be requested from the Internal Revenue Service. Along with setting up a business in the United States, you do have to also make sure that you customize your contracts, and there are a plethora of contracts. You also need to be aware of labor and employment laws here in the United States. And make sure also that your intellectual property is protected in the United States, because foreign IP, intellectual property, so for example, trademarks, are not protected in the US. So you would want to make sure that you protect your intellectual property in the US by filing at least a trademark. I wish I had more information. There is a lot more information to be obtained, especially when you are doing business in the United States. I do encourage you, however, to go to my website, which is baglalaw.com, and go to the international section on my site, and please download my free ebook. It is called Doing Business in the United States, and you will gain a lot more information from that booklet as to what you need to consider when doing business in the United States. It was a pleasure being your speaker today, and I thank you for your time.